furtherance of that disposition of the petition. This is a serious matter. As has been submitted by my learned colleagues, you have a duty to sit, and we urge you to sit and dispense justice in this matter. I'm most obliged.
My lady and my lords, hot on the heels of submissions by Mr. Nyamodi, now senior counsel, I wish to state as follows. My lady and my lords, the serpentine and sinuous submissions by Ndegwa and by my learned friend, senior counsel Fiona Mimba, just in case he says I was breastfeeding, must be faulted for two reasons. Number one, Mr. Haminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. That's important for context. It's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter the next president, Ford, took over for the next 3 years. I think it's instructing the Lord to refer to this impeachment because of the case of...
Nixon was never impeached.
He resigned.
Yes,
Let
us get things clear.
After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is needed. My Lord, I want to connect this to my submissions, that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My Lord, let me submit that in Gladys Bosch-Soleil versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listened to the histrionics from the petitioners, the court will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by Justice Richard Moore. Then they went to the second act of actually filing a complaint with the Judicial Service Commission, submitted to Isaac Omasa and duly approved, so this court can be scared away and done. My Lord, then the scheme was not complete. My Lord, Judge Ibrahim, at page 31 of the Gladys Bosch-Soleil decision, stated, my Lord, that the threshold for impeachments cannot, for recusal cannot be so low, and every allegation made of any form of bias must be proved through credible evidence. And I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a document pursuant to factual issues that the petitioner then attempted to withdraw in court. My Lord, that not only invites a criminal sanction under section 11, but what is more important, my Lord, is that false affidavits are not afraid of it and must be struck off. Because the penultimate paragraph in our favorite, my Lord, swears to the truthfulness of the whole document. Where therefore, my Lord, any part of that document is false, the full of it must be struck off. And I will further submit that to both applications, my Lord, that I have before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Malawi, and others, a court of appeal decision on the threshold that learned friend senior counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. But if that were the case, no judicial proceeding would be conducted in this country. And learned friend, senior counsel, Professor Kibu, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge will not sit on any bench to hear any case, because we are extracted from the same academic background and administration. Unless my learned friends are saying that. Yes, my Lord, in response to the suggestion that the Honorable Justice Bremer attended a wedding of the Speaker of the Senate, my Lord, my Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Kingi, Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or respondent in these matters. But number two, my lords, the Honorable Speaker King merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former deputy president. My Lord Honorable Kingi has not taken part in the appointment of this bench in any form. My Lord, clearly the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray. My Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think it should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, like, my Lord, the serious environmental criteria exercise has failed in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for complaint. My Lord, soon, parties will then apply for recusal on the basis, my Lord, that two judges or litigant and a judge belong to the same community. Thank you, my Lord.
Sorry, none of them is quite near me. So I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting are the saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of the Virunga Limited, where it has actually been shown that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. We can take a break for 10 minutes.